Yes, welcome to the No State Project. We are live from the fortified compound in Mesa, Arizona. Glad to be with you back here live on the big show. It has been a couple of weeks, so glad to be here. Buckle in. We've got 3 hours of Anarchy Radio right here on the Liberty Radio Network. That's LRN.FM. And also streaming live on my YouTube channel, which of course is No State Project. Yeah, you see what we're trying to keep it simple. If you're not subbed, then you won't know. And I have heard from the last broadcast people not getting a notification until almost the end of the show. So I do my best to send them out. So hopefully there's not going to be something like that where the show has been on for 2.5 hours and all of a sudden the notifications go out. So I guess subbing doesn't always help you out. But hey, that's YouTube for you. It is February 9th, 2019. Appreciate the continued support of the show. If you'd like to help support the show, and it really is needed, you could do so at markstevens.net. And there's also my sales account, which on a break, I will put that on. I'll get that back at markstevens.net. Someone who has been supporting the show for a while, and it is appreciated. I will say it's Rob in Seattle, and so he's got a couple of questions here or comments. Let's see. He says, on your show, you've talked in the past about the mass shootings in America. I suggest that you research the late William Cooper and read his book Beyond the Pale Horse, wherein he predicted the mass shooting the mass shootings that we have today. I think that most, if not all, of these shootings are mind control operations. Also, I think that Bush, Cheney were far worse than Trump so far. Bill Cooper was murdered right here in Arizona. It was northeast here of the valley. I remember that. It seemed to be something that was almost inevitable with someone like Bill Cooper. I'm not saying he deserved it, not by a long shot, but I tell you, I haven't read most of Beyond the Pale Horse, but I've read parts of it. And the thing is, there were mass shootings that were taking place when Bill Cooper did that, and this is in the 90s. I think he was killed in the late 90s. Maybe he was killed in 1997, 1998. I don't remember exactly when it was. I'm almost certain it was before the year 2000. I could be wrong on that. It's easy enough just to look that up. And I guess what I can do, because you can't really give the guy too much credit for predicting mass shootings because they didn't start. It's not like that. They had already been, they'd already been happening. So he was born in 1943, died in 2001. Okay, so I was wrong about that, but it was okay. So he died just after Bush took off, a few months after Bush took office. I wouldn't say that they had already been Columbine and a number of other school shootings had already happened. But so I wouldn't give him credit for that. I think most, if not all, of these shootings are mind control operations. I got to disagree there. I know there are false flags. I get that. But if you're conducting false flag operations for decades and not meeting the result, I mean, they always want to go after guns. I get it. Hey, even Trump, take the guns, due process later. But if their object was for gun confiscation, how many false flag operations over the course of 3 or more decades do you have to do before you just take the guns away? So, now and again, I have family, for example, with the San Bernardino. I have family that. Was a paramedic, was one of the first responders there. He actually treated people that were that were injured, and he saw the dead bodies. This idea that if you don't see the dead body, if it's not plastered on the media, then somehow they're not dead. That's not. I don't think that's true at all. I mean, we just had Albert Finney died, 82 years old, died a couple days ago. The actor. I didn't see the body. They're not posting pictures of the body. Is it just a mind control experiment? If it's mind control for a certain goal, they have failed absolutely miserably. And so you'd think that after 30 years they would move on to something else. So the San Bernardino shooting is just one example. You have actual parents of kids that were killed in Connecticut. That's why Alex Jones is having such a problem now. You have actual parents; they're not faking their kids' death. So I agree that there are definitely false flag operations, no doubt. Okay, but are the mass shootings all mind control experiments to bring about a new world order? So and take and confiscate the guns, because the only thing stopping the United States government from having complete totalitarian control like they do in China is because Americans have so many guns. They have much more sophisticated. Look, let's address this. Well, they can't win in Afghanistan, right? They can't win. We know that that's the longest war in American history. Or at least the longest foreign war in American history. Does anyone think for a second that Americans are going to actually fight the government for 17 years? I don't think so, especially when you have so many more troops here, and I don't see that happening. So I just don't get that all these mass shootings are all, or most, if not all. No. The San Bernardino shooting was real. That's just one example. So I can't. Maybe I don't. Maybe I don't know if a mass shooting was a false flag. I've gone through and I've seen a lot of the so-called evidence to try to show that these things are fake, and it just doesn't hold any water. I mean, they were saying that the Charlottesville, when he drove the car, that was a false flag. What was the point of the false flag? And again, I'm not saying this as anybody who is a lover of government. I'm an anarchist, and I would love to see government go away. I want things to be paid for on a voluntary basis. I rather that the service was provided on a voluntary basis, where there's not a prison system to get people to pay, which props up and keeps in place the ruling class. So I'm not, so keep that in mind. Well, I think obviously Rob understands that. I just, especially since I have a personal contact and family that was involved with the San Bernardino shooting, that absolutely, positively was not a false flag unless the government was involved in killing those people. But the idea is, with Newtown, Connecticut, that the entire thing was fake. There was no shooting, nobody died, it was all fake. But certainly the one in San Bernardino absolutely was not fake. I can't. No, I don't see that. This other part about Bush Cheney being far worse than Trump, I think that's true as far as the body count. And I think the Bush and Cheney, as bad as they were, they were some of the worst tyrants and mass murderers in history. No, there's no question about it. Donald Trump has only been in for a little more than 2 years. You got to, so just in those 2 years, we're up against the break. And for those watching the stream on YouTube, this is a radio broadcast. So bear with us. We're going to have a few minutes for the commercials, but I'll get the caller line going. It's 218-632-9399, 218-632-9399. The passcode is 2020 with the pound sign. We'll be right back. Yes, welcome back to the No State Project, live from the fortified compound here in Mesa, Arizona, for February 9th, 2019. You want to join the big show, 218-632-9399, 632-9399. The passcode is 2020 with the pound sign, and I can also take comments and questions on Skype, which is Frank Rizzo 3. I may be able to join you on there, but you gotta instant message me first. But the best way is to just call in the call-in number. And we'll get to the calls here briefly. And somebody. I don't know how they were able to do that. Hopefully that's not our troll. Wow, interesting. Anyway, I wanted to get back about George Bush, Dick Cheney. How the hell is that happening? We're going to mute that up from the board, so even if they get through, they won't be able to do that pounding, whatever they're doing. So if you're area code 904, just hold up, and we'll get you on. You're not, in fact, just a troll. So area code 904, just mute up. All right. Bush and Cheney, horrible people. Those two should be in prison the rest of their damn lives. There is absolutely no question. They lied. They had the complicit media to convince people of the administration's lies. There's no doubt thousands and thousands and thousands of people died. And even if you're some kind of Republican, you don't give a damn about brown people, we're talking American lives. American Republican lives died over there. So you still have the atrocities, every day. So you still have, Trump has blood on his hands for all what's happening in the Middle East under the direction of his administration, which includes Afghanistan. A bus of children was bombed. Oh, because you got to be these partnership with Saudi Arabia, one of the worst, most violent criminal organizations on the face of the earth. Of course, you got China, which is, wow. Yeah, I think it was the 30th anniversary of the Tiananmen Square massacre. But Trump is just so overtly corrupt. And I think that he brought a level of corruption to the presidency that, I mean, would make even LBJ blush and say, son, you gotta have some discretion. So I don't know if it's even worth discussing which one is worse. I would say that if someone like Trump was actually given 8 years, he could be just as bad on the violence scale as George Bush and Dick Cheney. And, hey, maybe that's where Trump got where he could shoot somebody on Fifth Avenue and get away with it. Dick Cheney shot a man in the face. Shot a man in the face. Nothing. Wouldn't go under oath when questioned about 9/11. George Bush absolutely refused to testify about what happened during 9/11. You want to talk about a false flag. He would not give statements under oath. He blocked for years any investigation into 9/11. He blocked it. So if blocking an investigation does not smack of duplicity and collusion, conspiracy, I don't know what just like Trump saying that trying to make a Dr. Seuss rhyme, you can't you can't have this with investigations. Just like Richard Nixon stopped this investigation. It's the brazenness, and you can see how other politicians, help him by not, by killing investigations. My gosh, Jeffrey Epstein, the known pedophile who was trafficking in children. Clinton Bill Clinton was a good friend of his and went to his parties. Donald Trump spoke very highly of Epstein and gets a sweetheart deal from somebody who's then appointed to the Trump administration. Oh, I don't want to spend much more time with these animals. They're all animals. They're all vicious criminals. So I just said, look, it's more of a pissing contest to try to say, well, this one's worse than the other one. They are irredeemable violent crooks. And the whole lot of them should spend the rest of their lives in prison. And yes, I see the irony of Congress investigating Trump. But I think his corruption is at like, epic proportions. How many people around him have gone to prison or pled guilty so far? And we're not talking about pleading guilty in a sense like when you had the Central Park Five that were shown to be innocent and he still wanted them hung, Trump. We're not talking about children under pressure just wanting to go home, pleading guilty. We're talking about people worth tens of millions of dollars. People who are unbelievably wealthy and are not used to being held accountable to any degree. So, I don't want to tolerate any racism and prejudicial stuff. Just real quick before we get to home bumming, because this was something that came out, and it's just such a ridiculously biased and prejudicial and bigoted question. Have I ever seen a Mexican doctor? My gosh, what? Yeah, I personally know Mexican doctors. One's in Riverside. I see him every couple of months for family. So yes, I personally know Mexican doctors. In fact, it's been reported, again, I haven't researched this, I don't know, that it was Mexican doctors, scientists, that have a cure for the HPV, the papillomavirus. So, Eva Ramon Gallegos. So, the idea that just white European, pasty white European people are the only ones who have ever had any kind of success, the only ones who have superior intellect or the intellect. Look at someone like Ben Carson, who I loathe as a person, of African descent, is one of a world-renowned neurosurgeon. But, Africans are intellectually, inferior to white Europeans. Yeah. Yeah, I don't want to entertain any more racist stuff like that the whites are racially or intellectually superior. That's not this show. So things like, show me a Mexican doctor. No, that's not going to cut it. That's a different show. That's a show where you get guilted into support. So, but we'll be back with our calls. Home Bumming It has a report for us, which I'm looking forward to hearing. Some damage control. And we'll hear from him on the other side of the break. And if you want to join me, it's 218-632-9399. 218-632-9399. Passcode is 2020 with the pound sign. So we'll be right back. Yes, welcome back to the No State Project right here on the Liberty Radio Network, LRN.FM. And streaming live from my fortified compound in Mesa, Arizona on my YouTube channel, No State Project. And I call it a fortified compound going back to the Ed and Elaine Brown, because the media, to portray people who don't drink the Kool-Aid, they actually question the legitimacy of government itself. We have to be demonized in the media. That's the complicit media there. Doesn't mean everything they say is fake. It doesn't mean that every negative story is a lie. They do fact check, but they certainly like to gang up on people that question the legitimacy of government. And so the Browns didn't live in a home or house. They lived in a fortified compound, so it sounds more ominous. It sounds evil. So their basement was an underground bunker. So that's why we say that. I want to get to our calls, but we do talk about anarchy on the show, and I want to define that. Anarchy meaning no rulers. I consider myself an anarchist because I like the political or the philosophy that having a ruling class is wrong. Having a group of people rule over others is just wrong. Violent domination is wrong. And so it's not a matter of no rules, it's no rulers. That the rules are basically do no harm. Live honestly, injure no one, give every man his due. Let the means be consistent with the end. If the end is to protect life, liberty, and property, then provide your services and interact with us on a basis that is consistent with that. Not like what government does, not what the ruling classes do, that they are the ones, the most violent aggressors against life, liberty, and property, or life, liberty, and the pursuit of happiness. But somebody who has been aggressed against and actually had a pretty good outcome is, he's been on the show before. We got Home Bumming It. Welcome back to the show. What's the report of good news here?
Well, okay. So it was a complete cover-up, but I had 4 allegations against me, all misdemeanors. 2 of them sitting down on the sidewalk, one of them riding a bicycle on the sidewalk, and one of them false reporting. They went ahead and they actually gave me my option of what I wanted to plead guilty to, with no probation, no time, no fines, and no fees. Just plead guilty to anything. And the reason why I believe that was because they were covering up for the cops going ahead and doing a false arrest. Now, I put the video evidence that they gave me online on YouTube, so anybody could go ahead and look it up. But yeah, it was, this really makes me question any time that they go ahead and decide that somebody's guilty or innocent or whatever, because it seems to be all legal determination. And as we know, legal determination is just based on, smoke up the butt. So it's not, none of it seems to be real. It's insane, man. It's insane. But I was, it was it was a meeting right before trial, and I had a choice to plead guilty or to go to trial. Now, if I went to trial, I probably would have not been found guilty on the first allegation, but I probably would have not gotten such a sweet deal on the other 3. So I weighed my, it was more of a damage control. And I actually told them that. I told the judge that. And, I was like, do you think that Rosa Parks should have taken a plea deal? I mean, it's insane. It's so insane. I found out that the guy that hit me in the head doesn't even have a guard card. The security company won't cooperate with giving me their insurance information. The store is contracted with the security company, and it's just all bullshit. So
yeah,
I don't know what to say.
Well, you've got a system that is run by men and women. Now, how those men and women get the money to do what they're doing? Well, they force strangers in the community under threat of punishment to give them that money. They're criminals. So, of course, they're not trying to administer justice. They're trying to give the appearance of justice. And they're trying to make it look like it's good. That's why that you have these shills called lawyers, not all of them, where you can have something like what happened to a friend of mine. You can ask 2 questions on cross-examination, and the judge freaks out and stops the trial right then and there, and finds you guilty. And people who love the system and who profit from the system will, good, see the system work, Mark. And you're like, yeah, but he didn't get cross-examination. Yes, he did. Just because you don't like that the judge limited your cross-examination, which he has discretion to do, just because you don't like that doesn't mean you don't have your day in court. You have the opportunity to defend yourself. You just did a bad job. They don't want to ever take into account the incredible bias on behalf of the judge, helping the prosecutor. They don't see that. Nope. It's and because they get away with it, because politicians and bureaucrats and judges, they have absolute immunity, they can be so brazen about it. I mean, it's just like that lawyer that called the show a few weeks ago. I forget his name off the top of my head, where he was saying that he's been in court And the lawyers are just, they can't believe the judge is saying what he's saying. And he says, for various reasons, he doesn't say anything. They just let him do it. Well, because they have to go back and they have to work there. You know, I learned, something that I learned from one of my Sicilian relatives was, you don't crap where you eat. Kabish. And, you know, and I think that's where why these lawyers, they just sit back and they let these judges do this. Because they're afraid. Because, hey, if I object, if I say something right now, I can enrage this judge, and I am not, I'm dead in the water. This guy's going to, you know, I'm going to have a mark on my back. Not that he's going to, you know, he won't get any favorable, anyway. But that's why they do, you know, that's my experience, why, and that's what I believe the evidence is that shows that, yeah, they're crooks, and they can get away with it. What does Ernie say? Why do they do it? Because they can. Ernest Hancock, of course.
Right. And, I mean, there was so many appealable errors in this whole thing, it wasn't even funny. I actually I asked a judge, I mean, I went through 5 judges, right?
Wow.
And I asked a judge, oh, yeah. I went through 5 judges, 2 doctors, competency hearing, you name it. I mean, come on, this has been going on for almost a year. And I asked him, you know, do I have a right to a fair and meaningful hearing here today? Twice, 2 different judges said, no, that's what trial is. You don't have a right. This is not a fair and meaningful hearing. This is arraignment. This is, you know, pre-trial or whatever. So, yeah, you know, and the final judge, you know, he wanted me to not go on with the jury trial and just have him judge the case. And I was like, no fucking way was I, excuse me.
Okay.
No way was I going to do that because, you know, he was going ahead when I was saying, well, what facts and evidence is the prosecution relying on to establish jurisdiction
hold on one
today?
second, home bombing it. We're up against the break. Got a mute shot. We'll be back. If you want to join me on the big show, 218-632-9399. 218-632-9399. The passcode is 2020 with the pound sign. And we'll be talking about anarchy, government abuse. And hey, you can even discuss if you disagree with me, because dissent is welcome. I just posted a new success story with a train wreck. So if you have issue with something like that, then give us a call. But we'll be back in just a moment. Yes, we're back here live on the No State Project, streaming on my YouTube channel, No State Project, and also, of course, originating from the Liberty Radio Network, LRN.FM. And you want to help support the big show, please do. It's at markstevens.net. You can also markstevens.sales.com. We'll get that link back up on the website hopefully today. You want to join me, 218-632-9399, 218-632-9399. We're going to bring Home Bumming It back. So, all right, Home Bumming It, just take off, start off where we left off. Did Home Bumming It drop off? Oh. Huh. Okay, well, we will see what we can do. He still shows that he's up there, but we'll have to go to looks like a Skype caller. I think we have a Skype caller here. You're live on the No State Project. What's your name? Where are you calling from?
Hey, Mark. How's it going? This is Imran.
Hey, Imran. Somebody was just asking about you the other day.
Uh-oh. Was it the FBI?
Yeah, I have regular conversations with the FBI. No, it was
okay.
No, somebody was doing some video work. I think it was Kim, and they had seen the video with Scott Bales. And you remember you were there you were there for that.
Oh yeah. So, well, I hope everything's well. I'm just a few miles down the road from you, but I was calling because you like to talk about cross-examining the police officer when they've claimed that when they've made a legal determination as to probable cause, like in an arrest in a criminal case.
Right.
Yeah. So my question is what happens if these fraudulent prosecutors go before a grand jury and they obtained probable cause that way. In that case, aren't you kind of screwed a bit because you cannot cross-examine grand jurors, correct?
No, you cannot.
So what do you do in that situation?
Well, you would still cross-examine the witnesses, and you could maybe get a motion to quash the indictment. See, but let's say none of the pretrial stuff works, and you have to go to trial. You have the opportunity still to cross-examine the police officers that were used and gave their testimony that the grand jury based their decision on.
Right. But the thing is I don't know about other states, but here in Arizona, correct? Arizona, what they do, what a lot of local police departments do, is they send in like one police officer to handle several different cases before a grand jury. And typically what that police officer will do is, even though he wasn't a witness in a case, he will read off the police report before the grand jury, and they obtain probable cause that way.
Okay.
I don't know if you know that. To me, that's a pretty fraudulent procedure because what they're doing is they're getting like Joe Blow police officer who was in no way a witness or any way involved in the case, and he's going before a grand jury on behalf of another police officer and reading that police officer's police report, and they're obtaining indictments that way. So what do you do in that situation? Because in that case, which police officer is going to show up to trial? Is it going to be the one that appeared before the grand jury, or is it going to be the one that supposedly wrote the police report in the first place?
Well, in something like that where you've been indicted and it's only with felonies that they do that, or misdemeanors at the federal level, the prosecution has to tell you who the witnesses are that they rely on. It's part of the pretrial disclosure, and part of Brady that with the witnesses they have with personal knowledge. You should also have a transcript of what happened at the grand jury, so you know the witness. You're going to know who actually testified, so that even if he's not on the list, you could call him to discredit him. You would think it would be sufficient that if you were able to destroy the testimony, the credibility, and the competency of the actual arresting officer. So let's say the police officer.
Are you there?
Yeah, I'm here. Yeah, you're on a phone.
Okay, sorry.
But
my phone messed up.
Yeah. So let me mute that up for the background noise. So you should be able to prevail if you're able to, on cross-examination, get the police officer who wrote the ticket and did the stop, and made the arrest, who actually didn't testify to the grand jury, but the one who did it, he was basing it off of that witness. We'll say that's witness A. So if you were to destroy the competency and credibility of that witness, that should knock out the credibility and admissibility of the one who testified in front of the grand jury. So if you're doing, what I would want to do is I would want to attack that in a motion to quash and see if I can get an evidentiary hearing on that, so I can attack the credibility of the statements that were raised. So you have the transcript. Get the I don't know how successful we would be in doing that, but I would certainly move to do that. I wouldn't want to wait to trial to be able to have to destroy the credibility, because it's so easy. It's just so easy to destroy the credibility. I mean, the prosecutors, they can't wait to jump up objecting to the competency or credibility of their own witness.
Right. So what I was wondering, though, is isn't this all fraud, though? I mean, how can they have someone... I know Chandler Police does it. I'm sure other local police like Phoenix and Mesa probably do it. I'm sure it's done otherwise throughout the United States. But how can they have someone who wasn't a witness to anything actually appear before the grand jury as a witness and make sworn statements?
I think, I would say it's grossly unfair. It's misleading. the grand jury, who are probably under the assumption that they are somebody with personal knowledge. Maybe they're getting around such a gross violation by, well, it's the grand jury. The rules of evidence don't apply. I don't think due process, allows them to do something unfair at the grand jury. You're talking about destroying somebody's life. Maybe somebody who's in it, you're ruining someone's life with an indictment. And to allow someone to testify that has no personal knowledge and no one's there to challenge it and bring that up, the prosecutor's not going to turn around and say, oh, ladies and gentlemen of the grand jury, this witness had absolutely nothing to do with the stop. He's going based just on the notes. And I'm like, well, why don't you get the cop in here who did it? Isn't that necessary? It's something I would certainly attack that, and it's not new. And the IRS has done that for years. I don't know. In fact, I've had IRS district counsel or U.S. assistant U.S. attorneys and say they don't know who did the assessment and don't think it's relevant. I have been attacked by attorneys because I believe that the one who actually did the assessment is necessary to a determination of whether that is true or not. And I have been vilified for the mere suggestion that they, just like with we're going back 8 years now to the Kimberly Clark tape recording. Here was an IRS lawyer who's basically pissing on the suggestion that she disclosed the agents who did the assessments. So, competence and credibility, not really high on their list for code violations. For mere code violations...
another thing... Go ahead.
I was just saying that for mere code violations where the government is the aggressor and it's not a real crime, they throw the rules right out the window. They couldn't care less that the witness doesn't have personal knowledge. I've said Rule 602 is one of the most ignored and abused rules in the rules of evidence, second only to maybe relevance, but it's bad, and so we have to accept that. So it's not what you're saying is grossly unfair. It's not new. I can't say how widespread it is, but I know from my personal experience, when it's the IRS or a regulatory agency like that, they do it all the time. But Imran, hold on just a moment. We're up against the, holy crap. Just hold tight. We're up against the top of the hour break. Wow, we are 1 hour in the can already. If you want to join me, it's 218-632-9399. Passcode is 2020 with the pound sign. We'll be back with Imran, and Home Bumming It is still with us. I don't know what the problem was, but hopefully we'll have him back there too. And we'll take your calls, especially if you have dissent. And we'll be back in about 4 or 5 minutes. So those watching YouTube stream, we are on a break. So we're hitting some peak numbers for the show right now. So please don't go anywhere. And I can still answer questions on the... Yes, welcome back. The second of 3 hours of Anarchy Radio right here on the Liberty Radio Network, LRN.FM. And streaming live, of course, this February 9th, 2019, from the fortified compound in Mesa, Arizona. And you can join me at 218-632-9399. 218-632-9399. Don't worry about missing anything because the podcast will be up at markstevens.net. I am always tearing down this here live feed after the show and just having the audio with all the commercial breaks cut out. So don't get too wrapped up in the comments. Let's get back to our calls. We'll get back to Home Bumming It, but we were talking with Imran about how unfair these people are, these prosecutors, when they bring unqualified witnesses to a grand jury. Imran.
Yes. Hey, in addition to what we were talking about, I would just like to say that it also speaks to more of our individuals in society if we have educated people that would pick up on all the unlawful things that these prosecutors do, such as bringing in non-witnesses and presenting them as witnesses and so forth, and so on. We wouldn't get indictments, and we wouldn't get innocent people thrown in jail or prison either.
Well,
Are you there?
Yeah, I'm here.
Yeah.
It requires more critical thought and analysis, not just blindly accepting what people say. That just not accepting this premise that just because you're physically in Arizona, a written instrument from 1910 not only applies to you and gives them jurisdiction, but actually creates obligations on you. And not accepting these stupid responses that, well, now you're arguing philosophy when you're just trying to hold someone to their burden of proof. You're just trying to get someone to verify their claim. And when these people, these criminals, can't do that, either they or their shills will start screeching, now you're arguing philosophy, which is mind-numbingly stupid. It's just an unbelievably stupid thing to say.
Right. Okay, well, I just wanted to check in with that, and, hope everything else is going well. Have a good one.
Thanks, I appreciate that. It's been a while. Imran, so I think we're going to repost my video with Imran. You can't see either one of us, but he was the one that was right before me questioning Scott Bales, the Chief Justice of the Arizona Supreme Court. We'll see. Did we got home bumming it back over here? I've got no audio from you, my friend. Damn it.
No, I'm here.
There he is. Okay.
I'm here. I had to wait for this line is unmuted to finish. So, it was just, and verbal armament, I'm telling you why. Because they were giving me everything I wanted. That's why. Now, I went ahead and I was talking to this guy that was in court for DUI. And he said, oh, yeah, of course, if there's rules, you have to follow them. And I was like, so you would have found Rosa Parks guilty. Is that what you're saying? She broke the rules. You're telling me you would have found Rosa Parks guilty. I mean, that's the thing. These people, they go ahead and they think, well, if there's rules, they apply, and you have to follow. There's an obligation because you exist. And it's like, I even had the district attorney tell me that, no, there's no obligation. I'm like, there's no obligation to follow. Well, of course there is. And, oh, really? Do you have evidence of that?
We got this here prison that we put other people in. Just once. And you were the one who sent to me, since I mentioned this, you sent me that Bill Montgomery, the Maricopa County attorney, who actually said that, and I have it in in an email. I have documentary proof of that. It's not just Jerry Cobb. But he threw his hat in the ring recently to be on the Supreme Court in Arizona.
Yeah.
Wow.
Yeah. And he's totally like he doesn't believe that prosecutorial misconduct exists. He has a blind eye to it. And everybody's saying this guy could not possibly be on the Supreme Court in Arizona and be impartial. It's impossible. Look at his record. I have other articles for you, by the way. They're going ahead and they're dismissing 47,000 more cases in, I think, Boston, New Hampshire for misconduct from the drug lab where they were testing drugs and things like that, and all their employees were basically taking hits off of the dope that they got, and it's all
we got to post a link to that.
It's all FUBAR, man. It's all FUBAR.
Wow.
And it's finally coming out.
Well, they had one that reported. I don't remember her name. It was it was an Indian name, an Indian doctor or lab tech. I think it was in Massachusetts also, but it was definitely the Northeast. And they had to get rid of hundreds of cases because she was messing with the results. She actually went to prison. Someone actually held accountable, which is really, really rare. But you're going to have to send me a link on that.
Guess what?
I'd like to see
two of
that.
them. There's two of them. I'm going to send you a link.
Okay, yeah, definitely got to check that out. Wow, that's pretty. Hopefully, it's against non-violent offenders, people who actually have not actually hurt anybody, and they're the ones that are getting there. It's not going to be someone who actually killed somebody and is getting out because the lab screwed stuff up.
Well, it's all drug lab things, so they're all going to be malprohibitors. But as far as whether or not they have ever hurt anybody in the past or anything like that, you know, those are probably going to be other allegations that they might have to deal with separately. But at least all the malprohibitors are going to be tossed out for like the last 8 years.
Wow.
78,000 different allegations. And yeah, I know.
Wow.
It's insane. These people just cover up all the BS that they do.
Yeah.
Now, this judge,
like Montgomery.
Let me get back to the last judge. I'm sorry, go ahead.
I was agreeing with you, just like Bill Montgomery. He's no Larry Krasner. Larry Krasner got fired a bunch, and a bunch of his prosecutors quit when he said, no, we are going to comply with Brady 100%. And he either fired them ones who did, or they quit. He was a cleaning house. Bill Montgomery, his office is a cesspool. He has more allegations, and his office has allegations where there are serial offenders, where people, just like Stephen Myrie at the federal level, that's just a regular part of what they do.
Yeah, no, totally. I'm telling you, I think it's systemic. You know, everybody's going ahead and doing what they got to do in order to get their paycheck, and none of the public pretenders, none of the district attorneys, and all these guys, none of them will look me in the eye anymore. It's really amazing how these people, they realize I know something that the rest of the sheeple don't, and they're like, oh no, we don't want to go ahead and deal with, let's not look at that guy. It's just amazing.
Why would they want to put their witness on a stand knowing that, one, the police officer lacks all the education that the prosecutor has. The prosecutor has an advanced university degree. He is head and shoulders above the police officer on intellectually. They are intellectually superior to the police officer. Why would they want to put someone who's intellectually inferior, who's literally just doing what he's told, why would they want to put him on the stand to answer a question the prosecutor couldn't answer and knows he can't answer? That's why when we asked the police officer for the facts supporting his determination of probable cause that the laws apply, that's why they freak out and say that they're not qualified. Hold on, we'll finish in the next segment. My name's Marc Stevens. You want to join us here on The Big Show, you may do so. 218-632-9399, 218-632-9399. The passcode is 2020. And for those on YouTube, we are going to a break as this is a radio broadcast, but I will still address your comments and questions on the chat. So we'll be back in just a moment. Yes, welcome back to the No State Project here on LRN.FM and the Liberty Radio Network. It's 4:20 Central Time, so, you know. Glad to be back with you here. We're talking about home bumming it. We'll finish there in this segment. If you want to join me on the broadcast, it's 218-632-9399, 218-632-9399. Real quick, one of the best Jerky Boys was when he does the ad for the chainsaw. Holy crap. Best not to be driving while you're listening to that one. That was awesome. So if you haven't heard that one, look it up. Jerky Boys chainsaw. Oh, I think he's doing it as Saul. Yeah, definitely one of the best ones. But home bumming it. Let's get you back here. Talking about systemic criminality. Because they can.
Oh my God. I can't trust it anymore. I can't trust anything these guys say or do anymore. It's insane. So I have a recording at the end of it was an informal conversation is what the judge called it. But my mother was in the room. And she wanted to be there because we weren't sure if I was going to actually be going to jail or not that day. And the judge, okay, so we go ahead and we go around and around and around about this jurisdiction. The judge goes ahead and says, well, the Constitution says that I have jurisdiction because blah, blah, blah. And, of course, he's diverting away from the prosecutor's evidence and ignoring that. By the way, JC, shalom manishma, yodeh bivri. So I go ahead and
you got yourself off point there a bit, but let me just address this point here when he's saying that the Constitution, and you say, well, I understand you believe that, but is there any actual evidence that applies to me?
Well, actually, I said, was that true just because you say so, or is there evidence to back up your claim?
Nice.
Nice. Go ahead.
I'm agreeing. I was just saying, yeah, that's a pretty nice follow up. Yeah, just like when the judge says something stupid like that.
Yeah, what does that have to do with me?
Yeah.
Is there personal jurisdiction? There's just so many ways to attack it, and it doesn't really matter because they're all working together to go ahead and to get you convicted. The thing is that you guys you're basically my only support. When the first thing that I was told when I got out of court as we were walking away was, oh, well, let's see how long it's going to take before you get another ticket. Oh yeah,
wow.
that's my mother.
Wow.
Yeah, she loves me. Oh, narcissism is really nice. It's a beautiful thing.
Yeah. Hey, that's so, hey, the judges run on that all day long.
Oh, tell me about it. So, it's like the district attorney was giving me just the best fucking deal they possibly
Come on,
could.
Big guy.
Excuse my French.
So they gave you a really good deal.
I'm sorry.
Hopefully, I'm sure some people are going to say you shouldn't have done that, but hey, under the circumstances and how long this was going, they gave you a deal, a smoking deal.
Well, and looking at the fact that I had 48 possible sheeple to ruin my life just because I was sitting down on the sidewalk with a sign in my hand or riding a bicycle, they'll say anything. Or they'll do anything that they're told. I can't trust them.
Yeah.
When you have people there with when you have people there on DUIs that are agreeing to the BS that's going on and the brainwashing, I can't help but just go, man, this is kind of hopeless. There's nobody here watching my back. I'm going to get nothing but flack, and I do not want to be put in a situation where I'm in jail because I am not. I'm 5'3", and people like to pick on me and test me out. I could easily end up in a fight where I have to go ahead and throw some guy off the second-story balcony just to go ahead and get everybody else to leave me alone, that I'm in there for another 10 or 20 years. I don't want to deal with that.
Just launch that bastard right off the roof.
Go ahead.
I said you launched that bastard right off the roof.
Yes, I would.
It seemed like a jerky. It seemed like the opportune time for a Jerky Boys reference there. So I had to go with it. But we're
fair
running
enough.
low.
I never saw the movie.
Well, it wasn't from the movie. It was one of the calls. But anyway, and somebody's saying the mechanic was the best Jerky Boys. Now, I'm going to interrupt here, and just before we're at a time, the best one was Brett Weir. The Super Across the Way. Hands down, the best Jerky Boys call ever. Ever.
I'm gonna have to look up that movie.
Look up Jerky Boys.
I've never
YouTube.
really got ahead and understood why anybody would call somebody and harass them on the phone or anything like that. But I'm curious as to what the movie is about.
No, the movie was
But-
garbage. You don't want to see the movie. You want to see the call. You want to listen to the calls on YouTube. The auto mechanic was great, but the car salesman, oh come on! I push his face right in the friggin' hood. You buy this car, I'll break your friggin' head. I had problems there, Paul. The mechanic great, and the house painter. Oh, but all right. I'm sorry. I can't. But bottom line, you got a really good deal, and I want to just address this about trusting them. I've said before, I'll continue saying it. When we're prepping for court, when you're dealing with these people, you have to be a skeptic and just assume that everything they're saying is a lie and get them to verify it. That should be the very basis of your defense, is assuming that everything they say is a lie and challenge them on it and make them prove it.
Everything they say is a lie. There is no question about that.
Pretty much.
That's what kills me, is even the public pretenders are lying to me, telling me, and they know. It's like I had one public pretender trying to go ahead and gain my trust and sort of, be on my side and go, oh, that's
well, home bum it. We're out of time. I got to let you go. But I appreciate the call. Congratulations on getting that kicked out with the damage control. You want to join me here on the No State Project? That's 218-632-9399, 218-632-9399. The passcode is 2020 with the #. And we'll be back in just a few moments. So, hey, watch some Jerky Boys. I know I'm probably going to. Yes, welcome back to the No State Project, live from the fortified compound in Mesa, Arizona, on LRN.FM, the Liberty Radio Network, and streaming live on my YouTube channel. And you want to join me on the big broadcast today. It is 218-632-9399, 218-632-9399. The passcode is 2020 with the #. And real quick, somebody mentioned about the Jerky Boys, the irate tile guy. Yeah. Yeah. Can you imagine being the guy that got that call and he is saying, well, I'm out here on it. Half these things are busted and I'm on a job. And all the guy can muster was, what color are they? Oh, good times. Yeah. Yes, and you can also join me on Skype. I haven't been checking that, so thank goodness. All right, I will get to Dean's question after. We're going to go to, he's been on the show before. We've got Chris in North Carolina. Welcome back.
Hey, how you doing, Mark?
Just trying to get through life without looking stupid, but it's not working out too well.
Well, if there's any consolation, you don't look that way to me.
Well, thank you. Yeah, good news?
Yeah, quick update. Yeah, I went to court on Tuesday, the 5th, and of course the prosecutor, the DA, claimed to not get my the discovery request and Brady request. But I conveniently had 3 copies there with me, so I said, well, here you go. Gave it to the bailiff. He got his copy, and I went downstairs and submitted 2 copies again to the court, the clerk of the court.
Well,
so I'm waiting to hear back.
Did the clerk of the court, did they get their courtesy copy? Do you know that?
I'm not sure if they got the first copy, but I took 2 more down there Tuesday and gave them 2 more copies. But they only took 1 and gave me back a copy, and a stamped copy.
Okay. Wow. I had a prosecutor, Craig Jones, and he tried to make the claim that he didn't get a copy. And I said, no, he's got a copy. He got a copy. I said, I can guarantee it. And the judge said, yeah, you can. And he said to Craig Jones, big mountain of a guy. And the judge says, my copy has a date stamp from your office, sir. the only way that Marc could have gotten this stamp was if he gave you a copy, and because we all knew at the time the prosecutor's office was behind 2 feet of glass, and so he said, now whether you had it in your office is not my concern. The man gave you a copy timely. What happened to it after that is it's your problem, but you were timely served.
Right.
Damn, that it was. I had actually won. I had the ticket thrown out that day, which was sweet. But we usually don't have to go through that.
Unfortunately, at the time, I couldn't afford to send it certified mail, so I sent it to the regular United States Postal Service.
Certified mail is glorified first class, so you can do a certificate of mailing, and that has the same weight as certified. That proves you mailed it. So it costs significantly less than certified mail.
Yeah, he's definitely got a copy now because the bailiff handed it to him in front of the judge.
Well, there you go. This is what they would call in the Army shucking and jiving. All they're doing is they're just going through the moves and trying to and they know they can make such stupid excuses because the judge is going to let them. The judge is always going to let the prosecutor get away with it unless you, like what I did, you have the goods against them. And even then is a lot of times they just let it go. We'll give them more time.
Yeah. Yep.
So they gave him more time. Well, contact me if you don't have a copy of the motion to dismiss for prosecutorial misconduct, and I would get that ready to go. If in 3 weeks they don't respond. If they don't give you a responsive answer.
All right. Well, now that's I believe that's in the motion to strike and dismiss that I got from you, because it points out that it is prosecutorial misconduct for him not to provide that evidence of jurisdiction.
Yeah, but there's one. It's only a couple pages long that I have that gives more. Right. It's specifically to dismiss for prosecutorial misconduct, where we're not saying that they're engaged in misconduct yet. So that you want to be able to put in your supporting facts, which at this particular point, you want to be able to look. I believe they lied that they didn't get a copy, because they did, but I gave them another copy, and now after 21 days, they still haven't responded.
Right. All right. Yeah. I don't know either before or after. That's up to you, but I really think you should call the Lenore County prosecutor here in North Carolina, because after I talked to you last time, I called again, and his secretary told me because it's a misdemeanor, they don't have to provide evidence at all, period.
Well, the prosecutor didn't say that. Just someone that when you called, it was a clerk or somebody, a administrative assistant. You weren't speaking to one of them.
Yeah.
Wow.
Yeah, I should have recorded that, because I looked it up in here in North Carolina. Only one party has nothing in court, and that's me. I don't have to tell them that I'm recording it.
Well, that's nice. It's like Arizona or at the federal level. Yeah, well, email me the contact information, because I would like to be able to follow up on that and say, look, it was reported to me. Someone had called this office and was told that because it's a misdemeanor, no evidence is necessary.
Yeah. I so wish I would have recorded that. But I found out afterwards that I could have recorded it without having to let her know that the competition was being recorded.
And to think, there are people that would support the clerk or the administrative assistant who said that, okay? And say that you or I are the idiots for even thinking evidence of a claim was necessary. Well, she's right. You don't need evidence in a misdemeanor. Yeah. Holy crap. Yeah. I'll see if they want to confirm that, and where I'll let them know I'm from the media and I want to be able to quote them on that. You sure about that? Wow.
Yeah. Yeah.
Yeah, it takes all kinds, and they don't like being challenged. Yeah, people.
Go ahead.
Oh, I'm done.
All right. Yeah, I looked at the state constitution, just to make sure, because I had, wanted to make sure that I wasn't, missing anything and such like that. I couldn't find nothing in there about that, about misdemeanors. Not they don't have to provide evidence for misdemeanors and such. So
yeah. Well, I've heard some really stupid things from these people. I had one in California tell me that she can't give me legal advice. This is a tax agent. I said, "No, you don't understand. I'm asking for the mailing address." "Sir, I cannot give you legal advice." "What are you on another line? What the hell's wrong with you? I'm asking for the mailing address." Yeah. So they'll say anything to avoid. It seems. Just hold tight. We're up against the break, so we'll be right back with Chris in North Carolina. It's just a crime you're being accused of. We don't need any actual evidence. Whether you agree or disagree, especially if you disagree with that, if you agree that that's true, give me a call here on the Big Show, 218-632-9399, 218-632-9399. The passcode is 2020 and the pound sign. But we'll be back in just a moment. Yes, welcome back to the Big Show. No State Project, live on the Liberty Radio Network and streaming live, of course, on my YouTube channel, No State Project. And you want to join me, 218-632-9399, 218-632-9399. The passcode is 2020. If you disagree with what I have presented on this show or other shows, then give us a call. If you think that there is evidence proving that the Constitution and Code apply and create obligations to us just because we're physically in Arizona or Australia, give us a call and present your evidence. Show where the logic is faulty. And just saying, well, the judge just can take judicial notice. You don't get to take judicial notice of a legal allegation. Do you think the judge is going... Here, let me ask. Chris, do you think a judge, in your experience, do you think a judge is actually going to take judicial notice of your legal allegations against the prosecution?
No.
No. Then why in the world would it be considered fair for the judge to take judicial notice of the prosecution's legal claim? Especially when judicial notice is for adjudicated facts, not legal claims.
Right.
Okay, so I forgot where you were.
The prosecution, because I had called him. I had actually talked to him prior to that, like I told you when I called him before, and I asked him, "Do you have evidence? Logical evidence backed up with facts, a written statement or statements that you actually have jurisdiction? I can't talk to you anything about your case because that would be legal advice."
Oh, that's legal advice.
Yeah.
Yep. I would fire back.
I'm asking you for your evidence.
I would fire back. Oh, if the police officer asked me for my driver's license, could I refuse on grounds that he's asking for legal advice? What a stupid thing.
Yeah. I mean, let me ask you a logical question, right? Because that's how you think, right? So
I try.
Is being in possession of a marijuana grinder, right? How is that violating anybody's constitutional rights? How does that violate anybody's right to life, liberty, property, or the pursuit of happiness?
How does that, or in legal terms, how does that constitute a legal injury or a violation of their code? Well, if there's evidence the code applies and they have prohibited that, it's not though, and it's mala prohibita.
Right.
It's only wrong. It's not wrong by its nature. It's only wrong because politicians said so. That's it. So that's why we attack, of course, for you and new people listening mainly. Okay, that's why we're attacking the foundation of the prosecution's case, which you did, asking him for such proof that just because physically in North Carolina the Constitution applies, and what do? They don't even argue, dude, you're an idiot. I mean, come on, we don't have to prove anything like that. And the judge is not going to let us. Show me one instance where this argument has been successful, Chris. They didn't say anything like that. He He lied to you, and I would bring that up in the prosecutorial misconduct motion. He lied to you.
Right.
It is not giving legal advice if you're asking him for the proof his arguments are based on. He's lying and doing a bad job at it.
Yep. Yeah. Because as far as I know, there was only ever one human being on this planet that God had draw up a written instrument to tell us what the laws are. Okay. And that's Moses.
Now, the thing is, we're going to be discussing evidence on the show. Let's stick to that. We know that their proof, their claim, has no proof.
Right.
Okay. It's zero, and you put them on the spot.
Right.
Only an idiot would argue that the prosecutor didn't have an obligation to provide disclosure. They do. And even if it's like New York where there's no pretrial discovery, Brady material is still required, and he still eventually has to disclose that to you. And that doesn't, if he was honest, which he wasn't, he would have said, I'm not required to give you the evidence I plan to use until the day of trial.
Right.
But he wasn't. He lied and said he can't give you legal advice. And I know there are lawyers who conflate, or equivocate, the advice is whatever they say, just asking a question is no. Let me take a moment to right here. When you do a cross-examination, are you asking the witness for legal advice?
No.
No. What? Because you're just asking questions, right?
Correct. Yes.
You're asking them for the evidence to support their claims that they've made on direct and in prior statements. You're not asking for legal advice.
Right.
Legal advice is when you want you want them to get you give them the facts and they apply the law and then they tell you give you a suggestion, because advice and suggestion are synonymous. They give you a suggestion on how you should proceed, and that's not what we're doing. Asking for proof is not asking for legal advice any more than a police officer is not asking for legal advice if he asks for a driver's license or registration. So, stupid lie that this guy told and got. But yeah, you get me the contact information, and maybe I can get a call of shame out of it.
Okay. All right, I will. I got your email. So, with that motion for prosecutorial misconduct, is that 21 business days, right? I
like to give them, the 21 days that they haven't responded, and then I file it. Yeah.
So I'll either mail it and make sure it gets there on the 8th of next month, or I might even hand deliver it to the courts and to the prosecution.
Well, the court, you could probably mail it to them and just get a certificate of mailing for the prosecutor. It only costs it's 65, 70 cents. It's $1 or less.
Okay.
So.
Right. All right.
Okay.
All right. We'll do. All right. I'll contact you by email.
All right. Sounds good. Appreciate the call.
All right. Yep. Thank you.
Chris in North Carolina, and we're going to be getting to the top of the hour break here in a couple minutes. So if you want to join me on the big show, 218-632-9399, 218-632-9399. It is just like it's a common theme because this is the way we defend ourselves about being a skeptic. That which is asserted without evidence can be dismissed without evidence. Those are some pretty true words to live your life by. It's being a skeptic. It's not just accepting something on faith because somebody told you. And so here we have to be a skeptic. These they can put you in jail. They can ruin your life. We cannot take anything they say, and I'm talking about politicians and bureaucrats. We can't take, or their supporters. You can't take their claims at face value. You can't just because someone is a lawyer, even a really successful lawyer. You can't take what they say at face value. You got to challenge it, make them prove it. I mean, if the critics, which there's only a handful, if they actually applied the same standard of proof that they do to me to the system that they revel and worship so much, they can't find fault with, my gosh, it would make their head spin. If they actually applied critical analysis to these claims and actually address why is it that if I was to make a claim that a written instrument applied to somebody and created obligations on them, that that they wouldn't just accept it if I said it. But if they don't accept it from me, why would they accept it from those? Because they profit from it. Lawyers are able to inflate their fees because they're a part of a monopoly. And they're not going to go and accept a very rare attorney like Marc Victor in Mesa. They're not going to start attacking the very system that enables them to live better than 75 to 80% of the population. Oh yeah, I got 3 cars, I got 2 houses, I got a few girlfriends on top of a wife and kids. Yeah, I'm going to start attacking the system that provides all this money. Yeah, I'm going to make $500 an hour without this monopoly. I have to prove what I say. Oh, but they don't have to. Nice double standard. But we'll get back to your calls and more. We're going to talk about an appearance as opposed to participation when we get back. For those on YouTube, we got the top of the hour break, so it will be about 4 or 5 minutes. But I'll be here on the chat. Yes, welcome back to the No State Project here on LRN.FM, the Liberty Radio Network, and streaming live on my YouTube channel. And it is live, of course, February 9th, 2019. I'm going to get back to the call. Somebody had mentioned something. Whoa. There it goes. That's going to screw some people up there for a second. Appearance. And so going to the actual law dictionary there, we got the trusty Ballantyne's Law Dictionary. And appearance. An outward manifestation. That's not what's interesting. That's not what we need here. The first act of a defendant in court being the overt act by which he submits himself to the court's jurisdiction, a formal or informal, direct or implied, written or oral submission by the defendant to the jurisdiction of the court in an action, and they are citing 5 American jurisprudence second. Appearance, or appear, section 14, which if you go to the American jurisprudence, it'll be cited. They'll cite Supreme Court or appellate court cases to justify that. So that's why I make a distinction in the motion to dismiss that in the first line that we are not appearing, because appearing is a weasel word. Okay, it's a technical word. It does not mean it's not. They're not using it in a lay sense. So I say, I am not appearing. I am participating under threat, duress, and coercion, because that's exactly what's happening. If the judge snaps at you, who's coercing you? Say, if I didn't show up here today, wouldn't you issue a warrant for my arrest? Well, yes, of course. You're the one threatening me. I am only here to avoid you from issuing a warrant against me. That's the only reason why I'm here. You are threatening me. Those are the facts. Right? Well, the facts don't, isn't that the alt-right thing, the Ben Shapiro thing? Facts don't care about your feelings. Well, here I agree. They don't get, yeah, those are the facts. If you don't like that I'm pointing out that I'm here on a threat, duress, and coercion, the one individual here that can change those facts is you. So, I don't know. Why would they get... They're on a power trip anyway. Why would they be upset that someone's calling them out on that? Of course you're there under threat, duress, and coercion. Of course. Hey. 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 All right. Let's. We make it clear we're not appearing. We are participating under threat, duress, and coercion. I'm not representing myself. I'm defending myself. Not the same thing, apparently, which is why they pushed it so hard. I guess when you... anyway, not that big. I guess that's not as big a distinction as appearing. Appearing, yeah, that's bad. I'm not appearing. Objection, I'm participating under threat, duress, and coercion, tough guy. So, okay. We'll get back to our calls. We got... okay, well... we've got, I think it's a Skype call. You're live on the No State Project. What's your name? Where you calling from? Oh. Try that again. You're live on the No State Project. Oh, they dropped off. Okay. Maybe we'll get them back. But we've got area code 201. You're live on the big show. What's your name? Where you calling from?
This is Amir Khan from New Jersey.
Oh, I'm sorry. I missed your name. What was that again?
Amir Khan from New Jersey.
Okay. And just for future reference, we just have to use first names. But welcome to the show. What can I do for you today?
Yeah. Basically, I sent you an email just about a couple of days ago, letting you know that I basically have bought the process from you in 2 years. We basically have tried in several different courts. For the traffic matters and the other civil matters, the judges actually declined to actually accept the no state project, and they says they do have the jurisdiction. I've explained to them they do have the jurisdiction within that square courtroom, but they don't have jurisdiction on me. I'm not the citizen of the state, so. They didn't actually get that. They just kept them going, and they send me the fines and all that kind of stuff. So I really need to know the right remedy, see what to do and how to do to handle this kind of situation here.
Okay.
Even though, let me interrupt you for 1 second. I'm basically a nation state citizen. So I'm not the U.S. citizen anymore. I basically give up my right to being a U.S. citizen. So I'm a national state citizen.
Yeah, I remember you putting that in an email. I wanted to, and I'll ask you about that. It's a nation. Say the phrase again. A nation what?
A national state citizen.
Wow. Yeah, that's it. That's why I remember asking you that and having you call the show. A couple things going on here. When the judge says something that they do have jurisdiction and they're opposing the motion, it's best just to object and ask if the prosecution has met their burden. Because remember, the entire basis of the motion to dismiss, well, except for one part, it's all based on a lack of evidence that the prosecution has to support their claim that just because you're physically in New Jersey, that their constitution applies, creates obligations on you, and gives them jurisdiction over you. It's also an essential element of subject matter jurisdiction because it goes to whether there's an actual case or controversy filed against you. Because for those who are new, subject matter jurisdiction does not mean that the court has jurisdiction over all traffic complaints. They have jurisdiction only of traffic cases. So two things going on. You have a physical complaint. Yes, it's written. Okay. And that has to contain the elements, the facts and the allegations, and that would show that there was a legal violation. That let's say that they I'm expecting that the music to come in, so I apologize. But they have to have facts to support their allegation that the laws apply and you violated them. And they don't have that. So that's why we want to make sure when we go in there, don't make affirmative statements. You certainly don't want to make affirmative statements that you're a citizen or a national state citizen. Because if you are making affirmative statements, you take the burden of proof off of the prosecution where it belongs. 100% of the time we should be focused on hammering away at the prosecution's burden of proof. All right. So if you don't want to make affirmative statements other than to say the prosecution hasn't made their case. Okay.
I basically have told them that they don't have the subject matter jurisdiction. They don't have the signed verified complaint. They don't have any injured party. All of that. But the judge kept saying it was you basically have break the law. I thought I was driving in total private capacity. I wasn't driving.
Okay.
In
We're
commerce.
Getting into a lot of. Okay, I gotta. All right, we're going to be up against a break in a second, so we can cover all this stuff. But there's a lot going on here. So it sounds like you've had some experience with sovereign and freemen on the land or patriot type arguments, and I want to address those and so that they have absolutely no merit whatsoever. So we're up against a break. So just hold tight. We'll be back and we'll discuss this in detail. Yeah, telling them, other than in the motion, telling them that they don't have jurisdiction, that there has to be an injured party, and that there's and that traveling in private, and that you weren't engaged in commerce, these sovereign type arguments, no good. And we'll discuss why in just a moment. So don't go away. Hey, it's 4:20 Mountain Standard Time. So if you're in the Mountain Standard Time, then enjoy the show a little bit more. But glad to be with you here. We're talking with Amir from New Jersey, and he's mentioning things that are very, especially this national state citizen thing. It just smacks of sovereign citizen or sovereign. I know it's a contradictory term, but or freeman on land, patriot type of stuff, and that stuff just has no merit. Even if we accept that some of the arguments may have some merit, making an argument like that where there is a mountain of contradictory court cases that they can cite, and which one if they've got two contradictory court citations from the same circuit, same appellate court, right? Which one do you think they're going to take? The one that supports the prosecution or the one that supports you? We want to hit them. We want to hit them where they breathe. And we want to knock out the foundation of their claim. Their claim is always the same thing. Yeah, physically in New Jersey, our laws apply. They have no proof of that. They're alleging that the laws apply and you violated them. They have no proof of that. And that's where it should always be an issue of fact. If you try to fight these people on pure issues of law and your legal interpretation, like, well, my legal interpretation is better than yours, and my brother can beat up your brother. If you do that, you're going to lose, and you're going to lose bad. Now, if you get into these other things, one, I don't know if, do you know that in New Jersey, are they like California? Do they require on a traffic case, do they require a verified complaint, or just one that the officer signs and it's basically a certification? Wait, did we lose him here? Hello? Okay, we'll try to get him back. You jump in. The other thing is injured party. That's something that we get into, of course, in the motion to dismiss, but we're saying there's no evidence to support the allegation, or if there even is an allegation that there's a legal injury. Now, the legal injury is typically going to be a violation of their code, but they don't have any actual relevant evidence to prove that. And so remember, relevance is king. What facts do they have that are relevant to proving the proposition? And the proposition is that you violated, that the laws apply and you violated them. So if you're looking at, well, the facts, let's say, for example, I don't have a driver's license. Does the fact that you don't have a driver's license, does that have any tendency? Is that relevant to proving the proposition that you were required to have the license and don't? I say it's not relevant until you can prove you were required to have it. And to be able to prove that you're required to have it, they have to prove the basic premise of their case is that you're physically in New Jersey, the laws apply. So if that's not proven, then having a driver's license or not having the driver's license is not relevant, because you can't possibly prove it does on its own. It doesn't prove the proposition's true. And this whole thing about private travel. At one time, 100 years ago, and you can find court cases, I've cited them, and I've also cited the ones that repealed them. The cases that stated that the use of the roads and the ordinary use of life, okay, was not extraordinary and wasn't licensed. So yeah, there are most places they didn't start out with a driver's license. Some they may have had a vehicle license. That came before the driver's license for the most part, but not a driver's license. But what they did, considering that they probably didn't figure it was going to take off the way it did, they changed their laws. So court cases that say you don't need a driver's license, even though they don't maybe don't explicitly state that, that's for the privilege, that the privilege is what they're taxing, like a hack, a hackney or a chauffeur. That is the using the roads in the course of a business is extraordinary use. And that is a privilege, that traveling is a matter of right and is not taxed. Those cases were overturned and I show this in Government Indicted. When the legislatures then went and converted the state right to travel to a taxable privilege, it overturned those cases. Those cases were not applicable anymore because it was not considered the ordinary use of the streets anymore. And as right. And you can shout from the rooftop and you can be all upset. Every Supreme Court where it was brought has upheld the right of the legislature to convert a state right into a privilege and tax it. The problem comes in with people who have a particular narrative. So what they'll do is they'll cherry pick Supreme Court decisions. And this is one of the things that got me out of the whole Patriot thing more than 20 years ago. Boy, some of them really didn't like me. Because the cases that say the Supreme Court is if the state tries to tax and regulate a right, you can ignore the legislation and the license with impunity. What they did was, and I've mentioned this like 100 times already, what they did was called cherry picking. They don't give you the entire citation of what the court actually ruled. What the court ruled on was saying that if the state government taxes and regulates as a privilege a federal right protected by the federal Constitution, then you may ignore the licensing scheme with impunity. But that is not what they're doing with a driver's license. They are taxing and regulating a state right to travel. So you got to be it's just like somebody posted here once during a live broadcast. They were saying that a statute is not law. Now, we've all heard this. It's a statute, it's not law. And what does it come from? It comes from cherry picking Supreme Court cases. This is a literal example of cherry picking, where they are deliberately taking something out to fit the narrative. And it's extremely dishonest. It is as dishonest as, what politicians do. What the Supreme Court actually said, and I did this during the live broadcast again, I'm not going to do it today. The Supreme Court actually ruled that an unconstitutional statute is not law. They didn't say a statute wasn't law. I mean, come on. Think about it. The Supreme Court, they upheld the enforcement of statutes every single day. Why would they do that if they were actually under the impression and have already previously ruled statutes aren't law? It is mind-bogglingly stupid. And people yet are still buying this stuff. And so we have to keep dismissing it. or debunking it rather. So hopefully we can get Amir back. My name is Marc Stevens. You're listening to the No State Project. We'll be back in just a few moments, so don't go away. Yes, welcome back to the No State Project. I'm not going to give the call-in number out anymore because we got a lot of stuff to get to, and I still have some Skype questions that I need to get to, and I may not be able to get them on the air, but I'll do the best I can. And I will mention, someone's asking about workshops. I used to do the workshops, but there wasn't any interest, and a few people here and there, so well, yeah, they're interested, and that we should create some interest in that. It's kind of funny. I'm at a point where I just don't, I can't let it bother me anymore. I would say here, if anyone's interested in a workshop, let's say, the old day things that we used to do, contact me on the website, markstevens@mail.com, and Skype. And, we'll try it again, and I will be able to report here that, hey, I can't even fill 100 seats on the live broadcast. So the idea that we're going to fill 30 seats on that for a workshop is those days are gone. But hey, I'll put it out there. And you guys, if you want to prove me wrong, I would be happy to do another workshop. It's been a long time. I actually got to play some guitar. I think that was maybe the last time I did a workshop. No, I did one in Utah about 4 years ago. So, but I'll put it out there. We'll see if we can get Amir back. Again, we are running out of time. Amir, we got you back?
Yes, Mark. I basically, the remedy what I have, let me just put out the bullet points, and then you can, talk about it. I told them that they don't have the subject matter jurisdiction whatsoever. Then I told them that they don't have the no verified, signed wet ink complaint. I also told them that there is no injured party. If it is, provide that. I also gave them the New Hampshire, driving law, now which is basically become official. So then I told them that I'm driving in private, not in commerce. So, prove that. Then I told them that I'm in a full, full faith on credit. So I do have the documents from the State Department stating that me any kind of citation comes in, I can simply write it off just like that. Based on the full faith on credit.
Oh my gosh!
I also
the
gave
name
a
game.
copy of my UCC 1308. So, the matter of fact, I also gave them my good standing certificate from the state of New Jersey. I also gave them a cease and desist paperwork. And I was driving with the U.S. DOT plate. So all of those things, they are like pretty become complicated. They want to start the trial on it. So I said I don't have any problem with that.
Wow.
I also have filed the writ of mandamus in a superior court as well. Against them. So let's see what kind of showdown what we're gonna have. So I basically also have put your process top on everything.
I wish you wouldn't have done that. Guys, if you're going to do this, if you're going to do things, what I believe is what we like to call the right way, an effective way where I can prove, like I just did again, don't mix up with this trash, this right to travel UCC garbage. Before I get into this, and I can't, I have another caller for the next segment, which is the last one.
Yeah.
The mandamus. What is the why did you file a mandamus? What are you looking to have done?
Writ of mandamus is basically my claim, proof of claim against the against the city and the state that they don't have any right to actually do so because under the common law they have no right to actually stopping anyone. So if they're there and if they're impounding somebody else's vehicle, they are basically reliable and responsible for that.
Okay.
So I basically have asking them $3 million damage on it.
Okay, Amir, there's so much wrong here that it would take me 5 more segments to address and debunk each particular part. But here, I grabbed this one first because I had an idea that that what you did with the mandamus was completely wrong. A mandamus is a writ, and it is from a higher court to a lower court, or from a court to an administrative agency, to perform a mandatory function of the job, and that it was not one with discretion. So when we do a mandamus, when I recommend doing a mandamus, it's usually when we have filed a motion to disqualify or recuse the judge, where if there is evidence of bias or the appearance of bias, then the rules make it a mandatory, non-discretionary duty for the judge to recuse themselves. So then if they deny that, then we have proper grounds to maintain a petition for a writ of mandamus. So hopefully you didn't lose a lot of money on the filing fee, because you're going to have that one tossed out, and they're going to laugh about that one. So anyone listening, please, that's not what a petition for writ of mandamus is. You are basically filing a tort complaint, which is not the same thing, obviously, as a petition for a writ of mandamus. This name game stuff is absolutely ridiculous. The UCC, I would need you, and I will look at it. Send me the citation that you're using where it says that the operator's license, it actually says in New Hampshire law that the driver's license is commercial only, and that there's because I don't believe that that's true. I've been through all this stuff. They're not accusing you of, you're not going to be able to convince, and I'll give you this much. Even if you could prove it was true that their code says it's only for commercial, there is no way on this earth you're going to convince any judge or an appellate court that your interpretation of that law is better and more valid than theirs. Going in and trying to defeat them on your interpretation of law, what you believe the law says, is a loser. And I believe that, Amir, even if I agree that your interpretation of the law is correct and theirs is wrong. It's a very bad way, a very ineffective way of defending yourself, to try to get them to agree. Now, if you did just with I'm doing it, their disagreement is really easy to show how unfair things are. If you're coming out and saying, look, based on this, the prosecution doesn't have any actual evidence, and they start to argue that the prosecution doesn't need evidence, well, obviously that's not true. But you're able to then at least be able to demonstrate to a higher court why they're wrong, and then doesn't mean that they're gonna accept it, but at least you'll have solid grounds to show that they are dead wrong on the facts. And your burden of proof on an issue of fact is a lot lower than the burden of proof on abuse of discretion, or they're reading the laws wrong, because they are not going to, they're going to look, again, they're going to have conflicting court decisions that are going to back up the decision. And their job is to affirm that decision. So I would say, please don't do any of that stuff. There's no merit. They're not even charging you under the UCC. And we're not even touching on this national state citizen. When you say you're a state citizen or a national state citizen, you are saying the Constitution applies to you, right?
No, I basically have filed the resignation of the from the U.S. Court laws and U.S. Citizenship rights. So I did have the paperwork sent it to the State Department. They acknowledged that, and that's how they issue the different passport and different passport reviews.
Okay, it just sounds. I have to let you go because I have some other calls I'm going to try to get in. We can do some more in another show or off air on email, but that stuff has no merit, my friend. We'll be back with the last segment. I'll do my best to get through that and to answer the Skype questions. Maybe I'll do the Skype questions after the LRN stream, but we'll be back in just a moment. Yes, welcome back to the No State Project last segment. We're going to do our best to get to our one last caller. Somebody here is saying, I'm wicked smart. I'm just assuming that I can't say that, but maybe they are from the Boston area. So that I can't read wicked smart without thinking about that. Real quick, Dean's asking, in a traffic court, must one produce a formal or written challenge to jurisdiction, or would questions such as those you mentioned and that are contained in your script sufficient to get on record? Can a magistrate even hear challenges? Yes, they can, and we can and should be doing it in writing and doing it when we go to court. So let me get to a caller. Area code 321, you're live on the big show. What's your name? Where are you calling from?
Again.
I'm sorry. Repeat that. I had
Florida. It's Paul from Florida.
Paul from Florida. What can I do for you today?
Yeah, we've spoken a couple times on the show. Hey, I'll kind of catch up on my situation. Driving with suspended license. Actually, I had two of them back to back because they gave me one while I was sitting in the parking lot. Do you remember that?
Yeah, I remember that.
Okay. And I just had that. Actually, I had that case or that hearing probably about 3 weeks ago, and I did get the judge to admit on tape that he did not have any evidence, but he still proceeded with the hearing and found me guilty, of course. So I'll deal with that later. But the original case, I did get the judge recused, so that was good. But the court date came and went with nothing from the court. I just now got in the mail today an order granting continuance, and now I've had to appear for another docket sounding all over again on this. So I really don't know how to respond to this. There's not even an address on where I'm supposed to appear on this piece of paper I have. Really strange.
Well, I would imagine it would be in the same court as before.
Well, the return address is at the secondary court.
Oh. Now, why they would take it in another court, I don't know. Maybe the availability of judges. Wow. Yeah, I guess Monday I'd give a call down there and ask them to clarify exactly where is this next hearing.
Should I file my motion to dismiss again with this?
I would. Yeah. Because the judge has been recused, and it was because of bias. That his determination on the motion is flawed because it was not based on the merits. It wasn't based on the record. It was based on bias, which is why he's been recused.
Sounds good. Any idea in terms of I guess, how do I go about appealing this other case where the judge continued, even though he admitted he had no evidence?
What happened on cross-examination with the cop?
Kind of the same thing. The judge, they did exactly what you said they normally do. They said he wasn't competent or that he could not answer that they didn't say not competent, and I said, well, isn't he making judgments every day while he's writing tickets? And again, the judge stepped in and said, yep, he is, but I'm still going to allow the testimony. So there's a lot of case for appeal, or a lot of issues for appeal with this particular case. So
right. Well, you've definitely, you've got him admitting he allowed it to go forward. So on just those two issues, he allowed it to go forward, admitting there was no evidence, and he refused to allow you to ask relevant cross-examination questions. He admitted he made these determinations. He made them for you. He makes them for other people, but he explicitly and deliberately did not allow you to question him on those prior statements. So on those two issues, denial of cross is the big one. Denial of cross-examination without waiver would be a constitutional error of the first magnitude, and no amount of showing a want of prejudice would cure it. Burkhardt versus Janus is just one of many cases citing that. So on that alone, you should. So you get it started by doing the notice of appeal, and I can send you that. But you also can do a petition for post-conviction relief. So you can, I know it goes to the same judge, but you give him the opportunity to do the right thing. He probably won't, but it's always worth, putting that in there because you're going to use a lot of these same arguments in your appeal. And use his words against him. Of course, you want to quote him as best that you can there. And when you were done, did he allow you to continue cross-examining the police officer until you felt that you couldn't go anymore, or did he just cut it off and find you guilty?
No, he did allow me to continue, but there wasn't a whole lot more to ask him. I could have he actually lied as part of his testimony, but I did not go that far because I didn't want to get into the weeds too much, because again, I didn't want to get off take my focus off of what you guys talk about.
Sure.
So he said that I had, again, this is the one where he came down after my original suspended license case. He was the bailiff in that case, and the judge sent him down to the parking lot, and I was sitting in my vehicle talking on the phone, and he pulled me out of the vehicle and gave me another driving while with a suspended license ticket. And he said I had pulled my vehicle partway out of the parking spot, and that was not true, because earlier on in his testimony he said I was backed up all the way against the bushes, which was correct. And then later on he said, well, no, I was pulled partway out in the lot, so I was going to ask him which one was it, but I didn't want to get into the weeds too much because I didn't know where I was going with that line of questioning. But anyhow, it was BS. We'll just be nice.
Yeah, we're about out of time, so I would just, what I said. He admitted there was no evidence. He proceeded anyway, so you got your violation of due process there. It's not fair for him to do that. It never should have went to trial. There wasn't sufficient evidence to do that. There's your bad faith also, and even though you got to cross-examine him, the phrase is effective cross-examination. So you were denied effective cross-examination, and it's very easy to show relevance. All the prosecution could argue was that your question, when it goes up on appeal, is they have to argue that the judge has discretion to limit cross-examination to relevant, questions and topics, which you are easily able to show. It went by the judge's own admission and the police officer's admission. He made these determinations. So the facts that those determinations were based on is absolutely relevant. And so you were denied a fair hearing on even if we just focused on so I would just raise the two issues. Those two issues could be the big one, and that's the petition, and I can get this to you after the show, the petition for post-conviction relief, and then just those two issues on appeal. Because if you can't win on a denial of cross-examination, which you can clearly show here, then nothing else would have convinced them. You had no chance. They're giving you proof. Dude, this was rigged from the start. It's all for appearances. So
I will send you also, if you want it. I did manage to take up about 20 minutes of their time. So it wasn't just an in and out. So I can send you that recording if you want to, if that'll help any too.
Yeah, I'll do my best to take a look at that. But get with me after the show, and I'll send you the notice of appeal, which is just that. It's just notice, no argument, and a post-conviction relief motion or a petition that you can edit for your situation. But the denial of cross will be in there, but it's not too difficult. Most of the heavy lifting has already been done. So,
thanks, Mark.
Hey, not a problem. I appreciate the call. I appreciate everyone calling into the big broadcast today. I have like 30 seconds left, so I'm going to... Okay, that's not... I'll have to address that. Too much to get into right now, but I do appreciate everyone tuning in to the big show. Hey, I appreciate the support of the show. And for those who are saying you're interested in doing a workshop is a little more involved. I'm not doing... I don't do them, on YouTube. It involves travel. So I usually charge between $50, $75, or $100, depending on where we're going, to be able to cover the expenses. So if you are interested in me doing a workshop, contact, and under the, because it would cost a little bit of money, then contact me at markstevens@mail.com, and we'll see what we can do. We will be live Wednesday, so hey, till then, salud.